So thank you all for joining us today from wherever you're joining. My name is Nashwa and this is Morgan. We're both partners that head the KTA US team for all outbound immigration to the United States. Today we're going to discuss possible changes, updates, or benefits that may arise during the Trump administration. Many of you may be eager to know where things are heading in terms of immigration. If we look back at Trump's first term, it provides us with strong clues as to potential policy and enforcement changes that may take place, although there is still some uncertainty about final changes. So Morgan and I will briefly cover potential changes to employment-based immigration, what employers should do, the E-2 visa process, and potential differences in adjudicating at United States Citizenship and Immigration Services versus the consular post in Tel Aviv. Also, green card options and changes to that, as well as entry on individual visas or the ESTA and what to prepare for. So, without further ado, I will begin with potential changes to employment-based immigration. All right, so what Trump's first term in office did not result in major legislative changes to immigration law, but we saw enforcement methods and interpretation of existing laws expanded and heightened from previous administrations. Potential changes in a second Trump administration could include some of the following. So there can be increased U.S. worksite visits. This means that if somebody is on an L visa or on an E visa, you could receive a visit from the United States Citizenship and Immigration Services. Further, we'll use it as USCIS, the Fraud Detection and National Security Unit. This is important to ensure that someone is always at the office. So if you have an office space, you want to make sure that during office hours, there is someone there, someone that can greet any person that comes, as well as making sure that the office that is listed on the forms is actually the office where you're working out of. Sometimes they can go there and they won't find anyone home, and then that's when they could open up to possibly re-adjudicate or a notice of an intent to revoke. Another anticipated thing that we believe may happen is that there will be more corporate investigations in relation to the protection of U.S. workers. So this is specifically for like your H-1B workers, any perm applications. So you want to make sure that on the hiring practices and on all of the forms that you are not having preferential treatment for your foreign workers. The employers need to specifically maintain detailed, organized, and compliant records at the relevant place of business in case an audit or a visit is made. Number two, we will see restrictions for visas and permanent residence from certain countries, especially in the previous Trump administration. There was the 2017 presidential proclamation. Now, this proclamation basically targeted countries for their failure to adequately share public safety and terrorism information about their nationals. However, this should not be an issue with our Israeli nationals, as information sharing between Israel and the United States is pretty strong and interchangeable. However, many of our clients may have companies that are outside of Israel and that are looking to bring, their foreign nationals to the United States. And so we'll continue to monitor and, post any sort of changes that come about in terms of third-party nationals and solutions for consular processing. Number three, we had a huge expansion in terms of the STEM fields under the Biden administration, which is the science, technology, engineering, and math applicants. And under Trump, there may be a debate between whether or not he will expand it or eliminate it. So we know that Elon Musk, who is he's an advocate for foreign employees, for highly skilled employees and STEM professionals. And he contributed greatly to Trump's campaign. So if he can win the ear of Trump, there may be benefits and extensions that can be made, as the Biden administration have done. Otherwise, you have, the other side of it, where you have Stephen Miller, who was his former Homeland Security advisor and now set to be chief of staff, who may take a much harsher approach, as we saw in the previous administration under Trump, that he did not want foreign workers to come to the United States, especially the highly skilled ones. So this program may be cut or eliminated if Miller is to take Trump's ear. And Morgan's going to expand more on that and some other visa options that may be available. Another one of the possible affected programs is going to be the H-1B. The H-1B program, Trump may be looking to increase prevailing wages depending on the geographical location and prospective employee job duties. And so also this looks to basically aim to price out like the employers and may have, more difficult hiring ability for employers if there are increases in prevailing wages under the H-1B. Another thing is expect more delays. More requests for evidence, and notices of an intent to revoke. We see this sometimes, now under this administration in terms of you're giving them a ton of information, a solid case, but they basically say, you didn't give us this information. Please make sure you meet the points. We will definitely see a lot more of that under the Trump administration. So it's really important to work with your attorney and to make sure that all of the information that you're providing is, solid, organized, and basically enough evidence to move forward. It's frustrating for the client, it's frustrating for us, but we want to make sure to work together with the employers and plan ahead to make sure that we have all the information that's required. Requests for evidence are kind of like a last resort in terms of trying to win back the adjudicator and to let them know that you are qualified under the specific visa that you're applying under. Another thing that we've seen under the previous Trump administration is not giving deference to previous visa approvals. So under Biden, there was a policy change where they would give deference to an application that was previously approved. So we always get a lot of clients that say, well, I received an approval the first time and even the second time. So this is, this should be straightforward and we should get an approval on it. Come under the Trump administration, no, not necessarily. And we anticipate the elimination of the current USCIS policy granting deference to previous work visa approvals. Another thing that we anticipate is the elimination of adjustment of status in terms of interview waiver and more in-person employment-based green card interviews. So what this means is that if you're in the green card process and you have an employment-based green card pending, you are more likely to now receive an interview before you receive your green card. This also would be a shift back to the initial administration, Trump administration, where green card interviews were extremely prevalent and high, and it just delays the process more, expanding it further beyond 2 years. So it's something to be aware of, and you may want to plan ahead in terms of when to file your green card application. Also expect delays in consular processing in terms of visa appointments, because there's going to be a huge turnover of officers at U.S. embassies and consulates around the world. And so you want to make sure that, you're planning ahead, making sure there's enough time. If applications are being placed into something called administrative processing, it's like being placed kind of in a black hole, and there's nothing that we can do to speed it up. The file gets sent to, the United States to do further investigation. And until that investigation is completely done, then they will proceed with moving forward with the case. Sometimes, I think the worst we've seen is like two years, 2 to 3 years, even 3 years. I think we had one person. And they then try to get congressional support if it's, someone of importance, or maybe they have business in the United States. You may try to opt to do something like that. But again, administrative processing is a really difficult I guess,
hurdle to overcome.
Exactly. And then just, a final thing that I'll put in there in terms of possible changes, and of course, Morgan's going to discuss more as she discusses her points, is that under the H-1B program, there may be more increase in denials. Right now, they're at about a 21% denial rate and may be increased to 24, 25%. Making it harder basically for those H-1Bs to get approved. So what can employers do? First of all, you want to review I-9 and E-Verify compliance protocols and conduct internal audits within your companies, especially if you haven't done them in the past 3-4 years. Ensure that all your employees are in status regularly and update any verification protocols in your system. Review also internal procedures and protocols to ensure that there's equal treatment again between your U.S. workers and your foreign workers, especially if they're under the H-1B program or if they're doing employment-based perm applications or labor certification from the Department of Labor. You want to make sure that the accuracy of the evidence that was also previously submitted is supported in any sort of green card application when you're going from a non-immigrant visa to a green card application. Also, you want to make sure that you're allocating enough of your budget to certain H-1B applicants or perm applicants, because again, as I said, the prevailing wages for those categories may increase. And so you want to make sure that the company has enough funds or a budget allocated for that, or for even any other immigration policies that change that we may not have, foreseen. And consider, filing your extensions and upgrading to premium processing for pending petitions as early as possible. So if you're, on the fence or debating as to whether you want to extend or you want to file a green card, now would be the great time to speak to us or your immigration attorney to kind of see what you can plan, what solutions you may have, what other options you may look to as a plan B if these changes take effect. And make sure that you talk to your immigration attorneys. And I know we cannot stress enough, like plan ahead. We get a lot of people that come to us, a month or even we've had a month before they expire, and they say we're expiring under this administration. It will be extremely, extremely difficult to get something like that approved and try to rush an application and you want to provide the best application possible with the most evidence. And we're here to answer any questions as needed. So Morgan is going to now delve into the investor visa and some differences between the different posts.
Yeah, so Nashra talked about the downside. We heard a lot about all the things that could change, mostly for the worse, based on the previous experience that we had. And it sounds very doom and gloomy, and it could be, but I'm going to talk about some of the areas where we could see some progress, some improvement, or how to, handle these changes in a way that's still beneficial for the business and for the employees that are relocating. First, we'll talk about investor visas. So the investor visa is the E2. It became available to Israelis in 2019. And basically, E2 visas are available for Israelis who have invested in a new or existing U.S. business. The business has to be at least 50% Israeli owned. It's got to be real and operating. The investment funds must be placed at risk and committed, meaning you've spent most of the money that you invested on getting the business to be operational. And the focus of this visa is, and we expect it to continue to be, the impact of the business on the local U.S. economy. So what is the business going to benefit the U.S.? And a lot of the ways that they decide whether it's to the benefit of the U.S. is, have you hired U.S. workers? Are you going to hire U.S. workers? That's already a consideration. We expect it to increase come Trump, and we saw that it did increase in the previous Trump administration. That's how they were deciding whether a U.S. business is beneficial or whether a treaty investor business is beneficial to the U.S. economy. One of the potential benefits of the E2 visa is that you apply for it directly at the embassy in Tel Aviv, at the consulate. And therefore get to bypass USCIS and sending the application to the US and all the, potential requests for evidence that we're expecting to increase, all the difficulties in adjudications that we're expecting to see an increase in. So standards could be starting to get more difficult in the US. However, the E2 standards at the embassy have remained fairly consistent across administrations. And we don't expect to see a significant change. The E2 standards at the embassy in Tel Aviv are actually stricter than the USCIS. They're a little bit different than the US. We expect it to remain fairly consistent. One thing we did see with the E2 and other applications in the last Trump administration was something called his Buy American, Hire American Act, or BAHA. And this kind of just had a overarching effect on all applications, and that consular officers were expected to think in the back of their minds, what's going to be the benefit for the US, what's going to be the benefit on US workers, and to deny things that don't have a clear US worker benefit. And so again, most of the focus on E2 visa processing at the embassy here is the amount of US workers hired. And we see this especially on extensions. So even if your business gets approved the first time, when you come back for the extension, they want to know how many US workers have you hired and is it proportional to your business? And so they want to see what is the effect on the local economy beyond just making a living for yourself, the treaty investor. And so we're already seeing a little bit of this focus. We expect it to increase. However, the standards at the embassy have remained consistent, and we're experts on how to navigate Tel Aviv and Jerusalem consular processing. Now we'll move on to green cards. So as we discussed, changes in the green card program could include increased interviews for employment-based green cards. Right now, we're seeing most employment-based green cards getting approved without an interview. That was not the case during the first Trump administration. We do expect the interviews to come back. This does dramatically increase the processing times for all green cards, whether you're called for an interview or not, just because of strain on the USCIS workers. To have to call everyone in for these interviews. This also resulted in the first Trump administration in a retrogression, meaning unavailability for some green card categories. This included the EB1s, which includes the multinational managers. Generally, we see these visas don't have a backlog, unlike the EB2 and EB3, which are the advanced degree and skilled workers. The backlogs for those categories come and go, but generally the EB1 doesn't have a backlog, although during Trump there were about 2 years where you basically could not file a multinational manager a green card. And this really affected the length of the processing times for all the green cards. And this time around, as we discussed, though, Trump is being advised by people such as Elon Musk and others, influential people in Silicon Valley who are from the tech world and used to highly skilled immigration and pushing for an increase in highly skilled immigration. They're pushing for changes in the quota system for green cards. They're pushing for, streamlined processes for green cards for highly skilled workers. And so, if these people win out and get to influence Trump's policies, then we could see positive changes in the green card world, particularly for these types of applicants, the highly skilled applicants. Trump has already suggested that he might be open to increasing the possibilities for green cards for graduates from U.S. universities. This could benefit some sectors. This could bring positive changes for green card processes that have become very time consuming and complicated. There's also a number of green card paths for highly skilled people that became really popular under the Biden administration. As we discussed, they had a really expansive, permissive policy for STEM employees. And so we saw increases in filings and approvals for green cards in categories of the EB1, the extraordinary ability, the EB2, the national interest waiver. We saw a lot of approvals for people in STEM fields, including cybersecurity, AI, food tech, ag tech, and startup founders across the board. So lots of these people that we mentioned that are advising Trump are trying to get him to keep and even expand upon these regulations that allowed a lot of people to qualify for different types of green cards that hadn't previously. We're continuing to monitor the situation and any changes in regulations regarding these processes. But we do hope that these kind of outside the box green cards will remain a good solution for people, especially in, the tech world. As always, as we mentioned, when it comes to green card filings, we encourage people who are thinking of filing to do so as soon as possible. The majority of the time that we see changes in regulations, it does result in an increase in processing time. It'll be more important than ever to consult with an immigration attorney, making sure all the filings comply with the latest regulations. These regulations are expected to change and oftentimes without much advance notice. So it's very important to make sure that, your filings are in compliance with whatever the latest regulations are. And finally, we will discuss the ESTA and the B1, B2. So as you all know, Israel has now the ESTA, the visa waiver program. This makes short-term business and pleasure travel to the U.S. easier. Most people will now qualify for an ESTA or a visa waiver by filling out a quick online form. That's, if you're approved, you're allowed to enter for the U.S. for up to 90 days at a time. And the ESTA itself is good for 2 years. This has reduced a lot of pressure on the embassy, freeing them up to adjudicate the student, the work, investor visas, and reducing the wait times for a B1, B2 visa. There could be a number of reasons why you're not eligible for ESTA, and you would still need to apply for a B visa. That includes a passport issue. ESTA is only available for people with a 10-year biometric passport. ESTA is not available for anyone with previous criminal or immigration violations. Or if you need to stay longer than 90 days or your purpose of your visit is inconsistent with the ESTA. It's always advisable to contact an attorney regarding what you can and cannot do on a visa or ESTA. We can guide you on what's the most appropriate choice for your individual situation. We don't anticipate seeing any major changes to either of these programs. However, we do always recommend getting attorney assistance with any of these complicated B visa applications. Anytime you have prior immigration history, some sort of violation, criminal history, anything out of the norm on the visa application, it is helpful to speak to an expert, someone that can consult regarding how to fill out the visa questionnaire and how to approach the consular officer for the best chance of success. One thing we did see during the first Trump administration was an increase in secondary searches at the border, more invasive searches like cell phones, social media. We did see an increase in a lot of that. So if those techniques come back and you do have concerns about your business travel to the U.S., whether on ESTA or on the B visa, we provide a travel consultation service, so we can advise on how to approach the border, facilitating a smoother entry. And we can also advise on what activities are permitted under ESTA or the B visa, or what would require a work visa.
Thank you, Morgan. And that concludes our brief seminar for you guys, and feel free to contact us. Our information is on the screen. We'd be happy to open it up now for short Q&A if you guys have questions. We can't answer anything specific to any cases, but if you have any general questions, we may be able to assist. So if you'd like to type in the chat, we can read a few questions and answers.
Sure, yeah, we're going to put up the contacts again, just a minute.
Not from here. 1 second. Yeah.
Yeah. So I have a question regarding updates to L visas. Nashua, do you want to take that while someone asked about updates to L visas and the process for green card from there?
Okay. Sorry, I don't see. I'm just trying to. Okay. Updates to for L visas. Was that the question?
Yeah, updates to L visas and the green card process from there.
So updates to the L visas is that you just want to make sure that we don't have anything concrete again. Like all of these are just what was previously, implemented in the previous Trump administration. But definitely the site visit. So making sure again that everything that you're filing on paper is exactly what your business is doing. So if you have any material changes in the business operations, if you decided to, change what your business is doing, that's something that we would need to look into to file an amendment. Any sort of changes in terms of the business location, you also want to let USCIS know in case there is some sort of site visit. And basically, if you're thinking about doing a green card, we would recommend not waiting until the maximum time on your L visa is up, but to do it after, if you're thinking about doing it and you've already been in the United States for at least a year, we would say try to look into filing the green card so you have enough run time in terms of, having an underlying visa application where you can continue to work and travel, but also a pending green card. Because again, we don't know how long these green cards can take. It can take anywhere between 2 years to 5 years. And that's being excessive, I know, but we just don't know how long these backlogs are going to be with the new interviews and issued and in progress.
So I see a couple more questions. One regarding what do you expect regarding the EAD process for spouses? I think, there will definitely, the EAD for the spouses of the H visas has always been very contentious. And that's where we've seen the most change across the years. They could work, they can't work. It goes back and forth. So we do anticipate seeing changes in that. Recently there was a change in the EAD requirements for E and L visa spouses. That was about 2.5, 3 years ago. We're clearly hoping that does not go back to where it was before, which in which the L and the E visa spouses had to file for an EAD. Now they don't have to, and you're eligible to work upon arrival in an L or E2 or L or E dependent status. We can't say. Again, I think it'll depend on, kind of whose worldview wins out amongst the people advising Trump, the one in favor of immigration and the ones against. If the ones against are getting to control the policy, then of course we're going to expect a lot more restrictions, including probably taking away the work processes, these extra work authorizations for the spouses, because it's one of their easiest ways to curb legal immigration. In regards to the E2 visa, is it 50% per individual or in a partnership 50% together combined?
So the 50% nationality rule is basically needs to be 50% of the entire organization, needs to be at least 50% Israeli owned. So if you have a company that owns it, you have to go up another level to see who are the individual shareholders, combining all of the shareholders that are Israeli together that don't hold U.S. citizenship or legal permanent resident status in order to meet the at least 51% threshold.
I saw also about for the E2 visa, they're a minimum amount. There's no stated minimum. There's nothing in the regulations regarding actual numbers. However, for us personally, in our experience, again, each consulate and embassy differs in the way that they adjudicate e-visas. In Tel Aviv, they like to see about $100,000. However, if it's very highly dependent on the type of business, how many people you're going to employ, what the overall business structure is. So it's super individual, and that my answer will definitely change depending on what type of business it is and what the plans for the business are. But yeah, I definitely wouldn't go less than 100,000. You want to read this one?
Yeah. Could you please elaborate on whether you anticipate any changes regarding L visas and changes concerning family members? The L visas we kind of covered, but in terms of family members, what we previously saw was if you're doing an extension from within the United States, you must also file an extension of status for the dependents during that time. And usually under the previous Trump administration, they separated the applications. And so sometimes you would get an approval for the principal applicant, and then the family members kind of being stuck. You're still in status if you filed on time, but you may not be able to work if you're a spouse because you can't get your work authorization updated. So that, may be an issue. And again, we have to see whether or not they're going to keep the incident to status, as Morgan said, work authorization, or if spouses will need to get new EADs. So that's something that may change. Again, we don't know for certain, but in the previous administration, they separated the application. So you had that issue where the principal applicant had status, the dependents were still technically in status, but not able to travel or do anything like that until they got their status approved. Right now, they generally, when you're doing an extension from within the U.S. on an L for a family, they adjudicate everything together. So that's.
Yeah, we're hoping that'll continue. It already creates a lot of problems, and it's really, that's why it's very advisable to, work closely with your immigration attorney, advise the attorneys of any travel plans, kind of, unfortunately, have to make your kind of 3 to 5 year plan in advance so that you can plan for extensions and travel and, green card filings and piece it all together of when you're going to do what, and taking into account all of the current regulations and any restrictions. So we see a lot of people that kind of maybe file too late or end up getting stuck in the US, unable to travel when they want to, because all these pieces kind of didn't fall into place as they should. It's complicated. It involves a lot of pre-planning and a lot of work.
Yeah. And just to kind of add to that is that, sometimes you get new regulations and policies that come out so suddenly.
Yeah.
And so you kind of have to learn how to, we kind of have to learn how to maneuver with that and to find alternative solutions for everyone, and to see what we can do. So it's just kind of like throwing a ball at us and seeing if we can catch it, and how can we catch it, and what can we do to.
And that's our job. I mean, we monitor, we're monitoring daily these regulations, making sure that we're up to date on everything that happens in the business immigration world. And so, you can always come to us for questions. Would you recommend to go ahead and file the L2 for family members sooner than later, even if they might join later on in the year? In this personal, me personally, for this situation, I always think it's good to keep the family together. We've had situations, especially in COVID times, where, families filed separately and then it ended up getting separated for an extended period of time just due to COVID lockdowns and changes in, visa processing at the embassy due to COVID.
Yeah.
I mean, especially in Israel with the war, visa processing is uncertain even in the best of times. And so, when you can file together, if you have an option to do so, I do always recommend filing together just to eliminate or, minimize the risk of the family being separated. I don't see any other questions right now. If anyone has anything, feel free to drop it in the chat. We'll wait a second. Thank you everyone for joining us. It's our pleasure to speak about these things. This is, our passion. And you saw our contact information there, so feel free to, email us, and we're happy to discuss anyone's individual situation. Thank you, everybody. Have a wonderful day. Bye-bye.
Bye.